We're going to discuss the proposed appointment of Edmond Alpha as Chief Electoral Commissioner as we continue the conversation on the amendment of the 1991 Constitution, among other things. So in the studio right now, we have Claude Bami Davis. He's the Public Relations Officer, Lawyers Society of Sierra Leone. And we have Ibrahim Faya Sawane. He's a legal practitioner. Gentlemen, thank you very much for joining us this morning.
Thank you very much for having us.
Thank you. Welcome.
Before we go to the broader constitutional review process, let's talk about Edmond Alpha's proposed position for Commissioner of the ECSL. What is the Lawyers Society position on this?
Thank you very much, Fabian, for that. We took a position particularly in consideration of the fact that there is an ongoing constitutional amendment which touches and concerns on this position similarly. And so the Lawyers Society, we're saying that the appointment during discussions surrounding constitutional amendments which capture this office may undermine the review process and the express will of the people as is documented in the CRC report and the tripartite committee report. Secondly, proceeding with this appointment before implementing recommendations 36 in the tripartite committee report and recommendation 8.10 in the CRC report, which call for the introduction of the search and nomination committee, could compromise the integrity of the reform process and indicate some perception of insufficient commitment to the genuine electoral reforms that we now seek. Proceeding with this appointment may or have the tendency to show recurrence of what happened in 2023 elections. And we know that the TRC, the tripartite, report emanated from the doubts, the challenges as observed in the 2023 elections. And it was formed because we want to curb those challenges going forward. And when it's going forward, it's 2028 elections. So our position is that the president should exercise restraint and rather call on the committee or the people that are tasked with the responsibility to expedite the process of this constitutional amendment bill so that we'll have the search and nomination committee, which tends to demonstrate some transparency in the process of appointing commissioners and people that are tasked with the responsibility of conducting elections.
And so far, what have been the actions of the Law Society in voicing out this opinion in the right corridors? I say this because the Speaker of Parliament is already has informed the public that they're open to position papers. Oh, yes. They want people to make input into the process. Beyond just engaging the media, what other methods have you used or means to communicate your position to the right authorities?
Yes, rightfully so. We submitted our position paper because, we have a position paper which highlights several of the amendments that are seeking to be done to the Constitution. And myself and the President, Augustine Soisengbe-Mara, we went to Parliament to submit our position paper. So apart from us coming out to the public and discussing or making known our position, we have submitted a paper to Parliament, to the Parliamentary Committee, for consideration. We have made a commitment to the people of Sierra Leone that we want to participate in governance, the protection of the rule of law and democracy. And most of the times what we're seen doing is to participate and to obtain or achieve that objective. And we trust that the Parliamentary Committee tasked with that responsibility will do the necessary consideration, and we will see that some of the positions we took, we recommended, would be affected into the constitutional amendment bill.
Ibrahim, do you share the same position as the Lawyers Society?
No. Thank you for having me. On the 17th, that was yesterday, I put out my individual position with respect to the subject. And in that position paper, I outlined the different constitutional provisions with respect to the process of appointing the Chief Electoral Commissioner. And one of the positions I hold so firmly in support of that position is the fact that the consultation process leading to the appointment of the Electoral Commissioner is a constitutional right vested solely on the President. And the provision of the law says he would appoint after consulting with leaders of political parties. And by the notice dated 10th February 2026, we have seen that the President, through the Office of the President, has requested the views of these political leaders. And so, for me, it does not in any way undermine the express will of the people. On the contrary, what the Lawyers Society wants is that the presidency should hearken to policies that have not been translated into laws. So you're talking about an ongoing review,
which the president says is very committed to doing.
Yes.
So in the spirit of being very committed to reviewing the Constitution, which yesterday we had the Deputy Speaker of Parliament, Honorable Ibrahim Tawakonte, in the studio, and he said, give and take, if all things go well, this process should and can be completed by April of 2026. It's just a couple of months away from now. In the spirit of willingness to get us to the constitutional review stage, again, looking at the genesis of how we even got here, many of the problems we've been having, especially in the electoral side, the issues we've been having, and the reforms now proposed, wouldn't it have been in the best interest of the country and the president's verbal commitment to wait until we get that process done, leading by example, and then now go by the review?
without serving as the spokesperson for the president?
No, not the president. I'm just looking at your opinion.
My opinion, without serving as spokesperson for the presidency. The Constitution gives the president the power to appoint the Electoral Commissioner. The process is ongoing. There is commitment to take it beyond the line. However, there should not be vacuum.
Is there a vacuum currently at ECSL?
There is an acting person in that position.
So is an acting person, does it constitute vacuum?
Impliedly. Because as we say, there is going to be an appointment. And if that appointment has not been done, and if the president has not followed the provisions of the Constitution, then we will begin to have issues within. He has not acted, as per my opinion, he has not acted outside of the dictates of the force of law. He's committed to whatever that is going on with respect to the constitutional review, and he's also committed to protecting the sanctity of the Constitution.
Could this not jeopardize, if we get to that stage now where the Constitution is reviewed, could this appointment now not jeopardize what we would be going into as per the review?
I don't think so. Parliament has the power to review, amend its laws at every given time. That is the reason why those people who are there have been elected. If they realize that what they have done or enacted conflicts with one or two other laws, it's their constitutional mandate to also amend it. And so it does not take away their powers, it does not reduce the force of the laws that they make at every given time.
What matters more? Because I know there are two things. there is the interpretation of the law, and there is the spirit of the law, even timing, which Fabian questioned now. The president is seen to be perhaps, if you like, the head of this whole reform, constitutional reform. It doesn't make much sense, if you ask perhaps a commonsensical thinker, for someone who's leading a reform to go behind the backs of the people whom he had chosen to lead this thing and do something else. It questions timing, but also it screams malafide, if you like, in Latin. It's ill-fated, if you like. A lot of people are now focusing on putting beautiful, literature in this bill that has been laid in Parliament, so that we do not resort to, having the rancor, the chaos that we once experienced in 2023. Now, be that as it may, at the end of the day, by the end of April, if you like, this thing would have been over with. And the president can, of course, through the committee, the search committee, appoint someone else. Why not wait? Why rush?
Has the president,
what's the rush about?
Has the president acted outside of his constitutional mandate?
So
that should be.
I know you're a legal person.
That should be the question.
So that, as I said, there is a spirit of the law and there is the interpretation of the law. Just because something is constitutional,
applying both the spirit and the letter of the law. Has the president acted outside of his mandate? If the answer to that question is no, then I will tell you timeliness. If you look at the provisions of the law, there is no time stated as to when the president should do what he has done.
I understand. But again, something that is quite crucial. Always, it's important to win the trust of the public, of the people, whom this president is governing.
And the people have representatives in the House of Parliament. And when Bami said it will also undermine the thrust, for want of words, the ongoing process, express will of the people. The people expressed their will in 2023, and the elected persons that are representing them in the House of Parliament. And so the express will of the people, we could get it from those members who are in the House of Parliament.
No, just a correction. So I said the express will of the people as documented in the CRC, the Constitutional Review Committee report, and the tripartite.
Okay,
not
the Constitutional Review Committee, it's a report.
Yeah.
These are proposed points, these are proposed objectives, these are proposed things that members of the different units that came together to put it as one document would want to see become law. They are not law at the moment.
And the president has said he's committed to making that becoming a law.
And I am sure the president will continue to give his commitment to ensuring that those recommendations that befit the necessary changes we want to see in our laws, touching on electoral reform and every other issues bordering on governance, I am sure, except otherwise, I am sure the president will continue to push those reforms and or objectives forward. But that does not stop him from continuing his role as president in appointing persons in these agencies and other bodies.
What if the president, chooses eventually to reappoint someone else? Then what becomes to this appointee?
It is his prerogative. He has the absolute power to do so. He can appoint. And there are provisions in the Act that says when one should be replaced and or removed from the said position. If the person is not fit to perform the functions, if the person is not performing the function, if the person resigns from the position, the president has the power. They can appoint, for example, he can appoint Edmond Alpha today. And tomorrow, Edmond Alpha does not fit into what he has been appointed, or he breaches provisions of the law. He can be removed.
Let's talk. I read your piece, by the way. Let's talk about consultation, which you are very big on in that piece. You quoted Black Law's Dictionary.
Yeah.
Sure, there is a case law. President of South Africa versus Safaru, 1999. The court ruled the Constitution must be meaningful not only ceremonial. So not in all cases, actually, does the interpretation of the law supersede the spirit of the law. It's a case, established case file.
And it's interesting. You say it's not in all cases.
Not in all
The
cases, especially
authority,
when we have an instrument before us.
First-
By the way, understand something. This thing, it's been like 3 decades coming. In fact, I even told the deputy speaker yesterday,
okay,
why they hadn't decided to do the entirety of this instrument rather than just cherry pick a particular section and do it. The chief minister had earlier said that they didn't have money to even fund a referendum. That's their argument. And they will tell you by spirit that's why they chose just this section, which affects perhaps the previous election, to do. But in good spirit, if they actually were thinking about the people of this country, then they would have done the entirety of this law. We have time.
Consultation is a procedural process. It is. In my piece, I have stated that consultation does not even mean consensus. Consultation does not mean the person have to accept your views.
But in democratic principles, that's the thing. You see,
Yes,
the law
consultation is a
conflicts
dialogue.
democracy.
Consultation is a dialogue. Consultation is a way of saying, let's share ideas.
Let me give you an
have
example.
an intention.
Let's say I'm about to employ a secretary. I've already hired this secretary.
You hired.
I've already hired.
Okay.
But I chose to tell you or ask your opinion or consent, if you like. Should I hire this person after I had hired, actually? Does that mean I actually consulted you?
I guess you have read the notice from the presidency. It is my intention to appoint Edmond Alpha. Therefore, I am asking for your views. The appointment has not taken place.
I understand.
Yes, and so it's different from the scenario you have cited. You made mention of the South African case. It's
Yes.
persuasive. However, when you look at the Constitution or whatever laws, when you're interpreting the laws, you look at the spirit behind the law and you also look at the wordings of the law.
Yeah.
Taking whatever instrument of interpretation, I will tell you that Section 32 of the Constitution Act number 6 of 1991, the spirit is consult. Bring them on board. Ask for the views. Discuss. In the event you see reasons to go by their opinions, you have that constitutional right to say, I will go by what they have said. Nothing stops, let's note this, nothing stops the president from saying, well, based on the consultations I have had, I am not going by the proposed appointment of Edmond Alpha. He has that power. It is not fixed, it's not sacrosanct that that is the person he is going to appoint.
You know, your argument, Bami, is about trust and timing, is it not so?
Yes, please.
Trust and timing. You know, but the Constitution is still in existence. It's the inforo domestico, the grown law of this country. Are you saying that the president must ignore current Constitution?
So, it's interesting.
Okay.
Now, the typical example, crude example would be by 10 o'clock this morning, you're desirous of having cassava leaves. Okay? Then the process of preparing cassava leaves for you, use this. And just at 9 a.m., you decide otherwise to eat pepper soup.
Potato leaf, my
Okay?
best.
What happens to the cassava leaves that they are preparing for you? It becomes a waste. So this is our point. There is already the introduction of the Search and Nomination Committee, which deals with the appointment of this office. Because when the Search and Nomination Committee is established, it tells you who are the people to form the Electoral Commission and blah, blah, blah. Right. If that is on course, and then the president has come to say, I am proceeding with the powers vested in me in Section 70 of the Constitution, disregarding an ongoing process. Unless the president wants to tell us that he is unsure that the amendment bill will take effect towards 2028 elections.
Okay.
Because if actually he believes in the process, we will think he would exercise restraint and call for the expedition of the process so that the introduction of the Search and Nomination Committee will come into effect. And let me tell you why we're bent on having this, we're supporting the Search and Nomination Committee. When you look at the very constitution, Sawane is saying, there are lots of confusions in it. Section 70, paragraph D, gives the powers to the president to appoint commissioners, chairmen, etc. So we are not questioning his powers, right? He made every whether the president has breached any constitutional provision. We're not saying he has. We're saying good conscience and timeliness, as you said, right? Now, section 70 says the president, 70 paragraph D, says the president, I'm just unfolding the confusion for us to understand why we want this search.
We'll allow someone else well to take a bite.
Yes. So section 70 talks about the power of appointment vested in the president. It gives the president the power to appoint the Chief Justice, the Justice of the Supreme Court, CD, Auditor General, and D, the sole commissioner or the chairman and other members of any commission established by this constitution. Any commission established by this constitution, which includes the Electoral Commission.
Okay.
That is section 70. Now come to section 34. Subsection 2. Keep in mind that section 70 has already empowered the president to appoint chairmen and commissioners. Section 34 subsection 2 says, I'm reading directly from the constitution. In fact, I have not used my phone so that I'm not being suspected of inputting words. Now, the members of the commission other than the Chief Electoral Commissioner shall be appointed by the President, subject to the approval of Parliament. What does other than the Chief Electoral Commissioner means? That save for this Chief Electoral Commissioner, that is, the President cannot appoint the Chief Electoral. These are the legal issues. So he can appoint all other
these are lacunas, if you like.
Exactly.
Okay.
Right? Say the members of the commission, other than the Chief Electoral Commissioner, shall be appointed by the President, subject to the approval of
But
Parliament.
the precedents we've had over the years is
Yes.
the President
Good.
does that appointment.
So-
and
so-
President Bio is not the first president
Very well.
to make
So
that
that
appointment.
is why we have welcomed these proposals, because they would curb all of these, you call it lacuna, they would curb all of these gaps, these gaps in the or these several ambiguities that this constitution have, right? Now, so you see this, you say, other than the Chief Electoral Commissioner, which means that person is precluded from being appointed by the president, by this constitution, by this provision. And now, he mentioned...
But the further down, it said, subject to parliamentary approval.
Yes.
Yes.
That's it. He's saying the members of the commission, other than the Chief Electoral Commissioner, save for the Chief Electoral Commissioner, the members of the commission can be appointed by the President, subject to parliamentary approval. So this tells you that there seems to be some further method by which the Chief Electoral Commissioner should be appointed. This is the Constitution. Now take section 32, which is the provision under which the letter from the Secretary to the President was sent. It says, section 32, the members of the section 32 sub 2. Section 32 establishes the Electoral Commission, right? So there shall be an Electoral Commission for Sierra Leone. Sub 2 says the members of the Electoral Commission shall be, now they are identifying the members of the Electoral Commission. The Chief Electoral Commissioner, who shall be the chairman, and 4 other members who shall be known as electoral commissioners. So these are the members of the commission, Electoral Commission. Then 3 now comes, says sub 3. The members of the Electoral Commission shall be appointed by the President after the operative word there is after consultation. What we have seen, in our opinion, is an appointment being done and now consulting after the appointment. We think it is our opinion, our position, that a form of consultation ought to first have been done. President comes to the political party leaders. I have Mr. ABCXYZ that I'm contemplating. I have, in fact, I mean, good practice will be identify 2 or 3 people. Consultation would mean effective dialogue, not sending a letter and asking for a review. And after that consultation should be when we should see a letter coming that, having consulted with the political leaders, I now appoint, right? That is the proper way to have. I mean, he was referring to consultation, and that he has a personal opinion, a legal opinion. So this is our point.
Let's take the blame away from the president a bit to Parliament.
Yes.
The president only has the power to appoint, but Parliament has the power to approve or deny that appointment.
Correct.
Putting all the blame on the president alone, leaving the Parliament, when over the years we've seen even the president, that President Bio succeeded. President Anes Baikoma did the same thing. Yes. It was going about the nomination exactly as President Bio is doing it now. But it still comes back to Parliament approving or denying. How much responsibility should Parliament be taking in all of this? Because when these are all pre-elections issues that lead to post-election conflict. Look at where we are. This is 2026. The main opposition, APC, is still saying the 2023 elections were stolen. And these are all from pre-elections issues, starting with the trust deficit on who was appointed, first of all, to serve in that capacity. How much blame and responsibility should the Parliament of Sierra Leone take when it's not only constituted of SLPP members, but APC members are also in Parliament, paramount chiefs and all?
Yes, that's a good one. But past events have taught us well, right? How many times have we ever seen an appointee by the president being or not being approved? How many times?
But doesn't Parliament have that power?
No, the Parliament does have. I mean, we're not taking that. But practice over time, in fact, some quarters will say, oh, we don't want to hurt His Excellency the President. People will say, yes, we don't want to hurt His Excellency the President. Because he is appointed.
But they would rather hurt the nation.
Well, that is for their consideration. But then, we have seen occasions which require 2/3 majority approval. We have seen a party leaving the well of Parliament, not in attendance. There are many gimmicks to it. So we're saying the first port of call is the president, who has that power, because it is unlikely, I mean, let me make it clear, it is very unlikely that Parliament would not approve the appointee of the president. So we're calling, because he's the fountain, okay? So we're calling on him to sort of exercise that restraint in this circumstance. Wait for the Research and Nomination Committee. Call on them to expedite. You just mentioned that by April, we would have been done and dusted with this one. Proposed. So April to November, because don't forget again, the Constitutional Amendment Bill is saying the elections are to be held in November of 2027. So that is well over 18 months. Well over 18 months. We understand the elections are processes, not events, right? You start the preparations. But if you're coming now as if the elections are in December, no, we have a whole year in 2027. We have over 18 months, as I have noted. So just restraint and call on the people that are tasked with this responsibility to expedite it. You know, just as you mentioned again, Fabian, the president has made a commitment to following these recommendations, because I listened to somebody who was saying, I think the day before yesterday, that president is committed to leaving a country with an electoral process that is transparent and fair. And that is why he's in support of the tripartite recommendations, 80 of them. Now, if that is his commitment, it starts now. So that is why we're saying we want him to listen. Maybe he had thought that well, I am waiting on them, but I haven't heard from them, and it seems as if these recommendations have a stalemate, and I am not going to wait. But if he has the power, or not but if he has the power, he can call on those people that are tasked with that responsibility to expedite this process. Tell them, I want these recommendations to form part of our laws. Sawane talks about they are not yet laws. Yes, we know they are not yet laws. They are recommendations. And that is why those recommendations are now in the process of being reflected in our ground, in the book or the Bible of this country. So once that is what we're calling. We're not saying just act on the recommendations. We are throwing weight on the fact that it is being reflected in the Constitution as amendments. And that is what we want. So we have the legality, the authenticity, and the mandate to act by what is being recommended and inputted into the Constitution.
You know, again, I'll refer to a case law. In 24 versus Attorney General Ghana, 1980, the rule that constitutional text prevails explicitly over political expectations, which is a perfect way to explain what's happening now.
Yes.
Wouldn't that cripple your argument, perhaps in any way?
No. We're saying the process should form part, the recommendations should form part of our Constitution. That is our view. We're not saying, oh, let's just work on the recommendations as there.
Let's say this man is appointed, eventually. Yes. Parliament agrees, comes to the office. And then after this bill has been, perhaps, if you like, ratified in Parliament, then the President chooses eventually to say, you know what, I'm going to remove this man again. It is his part to appoint and disappoint people, right? He has that authority, is it not so?
Yeah.
So he can choose, perhaps eventually, if I could make an argument for the other side, that, you know what, I'm going to let this committee now, which the Constitution gives power, to do the job and remove this man. Don't you think that would happen?
Oh, no.
It wouldn't.
Sawane again, taken by his words, mentioned that there are processes by which you remove. So once he's appointed and approved by Parliament, we think, don't forget, the Constitution, again, the same Constitution is not amended because electoral commissioners have terms. So once he is appointed, he should stay there until his term expires. So we cannot be breathing at one breath on a certain provision, and then on the other angle, we're saying, no, you can still remove him and go back to the nominee. We want to avoid all of those messy situations. But so let's stick by the dictates of the Constitution.
So, you know, Parliament is currently considering replacing, you know, the appointment method, which is in there now, with this, you know, search committee, as you know. My question is, by acting now, isn't the executive overriding the legislature?
Before I answer that question, he made mention of sections 34, and he said the caveat except other than the Chief Electoral Commissioner. I wanted to say that the Chief Electoral Commissioner's appointment is provided for in 32. So it is a statutory appointment. He goes to PPRC as a representative on that commission. So there is no confusion in that. It's so explicit. It is like you saying a member of the Sierra Leone Bar Association representing the bar on the Law Reform Commission.
By this law you're holding, is there a particular timeline for consultations?
No. In fact, my opinion captures it. There is no timeline for consultation. It could take the president 1 year to consult. It could take him a day to consult. It depends on how he wants it. The Constitution does not make provision.
Many people perhaps were involved in this consultation process before he considered, you know, appointing this man.
Sorry?
Do you have any inkling about, you know, the people who were involved?
Well, from the letter we saw. From the letter we saw in the public, there are up to 9 or 10 political party leaders, because the act says you have to consult the leaders of political parties, and those, as per that document, those are the people we think he has consulted and the discussion is ongoing. And Bami was talking about time consideration. We cannot sacrifice the
don't forget to ask you a question.
I'm coming to that. Okay. Maybe you can rephrase it. We cannot sacrifice the letters of the law with respect to emotions and political consideration. No, we cannot. If you do that, you are going against the ground norm of the land. And I will also state, this constitutional review has been in existence for over 10 years. And to date, we are still grappling with amending provisions of the Constitution.
Why is that so? It shouldn't be the
well, I am not a member of Parliament. I am not a member of Parliament. When it comes to constitutional review, there is a body responsible for putting together this document. They take it to our elected members. That is their position. That is their power. That is their function, their duties. And let us also note that there is separation of power. The executive has its own responsibility.
Which is why I asked you this question.
Yeah,
if the executive is not overriding the legislature.
No, I am timely. No, there is no override here.
Okay.
The executive has the power to appoint the person representing the Electoral Commission as head. There are three phases to it: the consultative process, the appointment process, and the approval process. These are layers. I appoint, I send this person to you. It is your duty to vet the person to see whether the appointment I have made meets the provisions of the law that I have relied on to appointing this person. Bami said we have never, it's rare for us to see parliaments refusing the refusing approval of the appointment of presidential appointees. I could remember as early as 2018, someone was appointed to serve as the ombudsman for this country. Parliament refused to approve that appointment, and one-time minister of information and communication, what is his name again? He was head of excuse me. He said he was also refused being approved by Parliament when he was appointed by Sludge to represent Sludge on a particular committee. So they have the power. Nothing stops them. And you see, that is where we have the uniqueness of governance. If Parliament says, Mr. President, we do not agree with this appointment, he has that power to go again and look at any other person and go through the process of consultation.
Going by history, do you think...
No, we cannot sacrifice the law on history. Let's look at what the law says.
Do you think, in good conscience, that Parliament can refute accepting this man?
It is their power. They have the power. They can do it. Now, let's come to your question. Please rephrase.
So, I mean, you've made an explanation, but the genealogy of this started right from the Truth and Reconciliation Commission report.
Correct.
And the recommendations therein.
Correct.
Now, but if we are discussing this in a broader context, I was asking whether you think, generally, that perhaps the president is too hasty. Doesn't, the executive, override legislation in this case?
As long as there is no timeliness provided, as long as
there's no time. Yesterday, the Deputy Speaker said, by April ending, as Phoebe has said, they would have been...
Deputy Speaker, that is what he has said.
Yes.
That is Parliament.
Okay.
He is not the only person there. There are political parties representing people, I think 132 or so, and they are paramount chiefs.
Just APC and SLPP?
Yes.
You said there are political parties. It's just the APC
just
and the
two.
Well, two is not just. The people decided to, the people, based on the vote they cast, they said, these are the people who want
so it's just APC and SLPP as political parties.
Okay, I would go by the just.
Okay.
Two, the Deputy Speaker, you said, said here that by April, the proposed amendments would have been completed.
Yeah.
That could be the case. Could be the case, in parentheses.
Okay.
Members of the House could say, no, we still need time to go through this proposed bill. Vet it thoroughly, because we do not just make laws for 2-3 days or 2-3 years. Our laws, the ground norm, has been in existence since 1991. And now we are looking at it and say there are lacunas. There are gray areas that we need to fine tune. So the parliamentarians might say, well, no, we are not rushing this. Let's look at this proposed bill. Let's see whether there are entrenched clauses in it. And if there are entrenched clauses in it as provided for in section 108, then we have to go to referendum.
Yes, I know.
And it will have to take time. It has to take money. And so we don't know.
The same referendum that the chief minister had said that they don't have money to sponsor.
And so that is why I am saying, the deputy speaker said here that by April everything would have been completed. We don't know. I have not
But
taken
man was
my...
speaking as an authority of the well. What if they had consulted others?
It is what if. It is conditional. We don't know. Members of parliament, they are also coming from political parties. And even though they are representing their constituents, they are also representing political parties because they went there under the ticket of their political parties. They may want to
argue that the last election, it is only symbols that was voted for, not these people actually.
Yeah, but they are representing parties. They are individual representing
parties. It is the parties that chose them, not the people.
Well, indirectly, it is the party. Indirectly, because they went to lower levels and they choose the executive by layers and they went to that point. What I am saying
let's agree with you, yes.
What I'm saying, the members of parliament can go back and say, well, no, we have to go and consult our political heads. And let's see what they say with respect to clause so, clause this, clause that. And they will tell you, no, well, let's not go by it. I have seen on social media too many other position papers and people pinpointing provisions of this new amendment bill. And coming from political heads, political leaders and other opinion leaders, let us not just rush into it and say, yes, we have amended our constitution.
You know, to be honest with you, the speaker was very clear yesterday. The only area they have a very strong contention with is the introduction of the, electoral system that we'll be using. That's the PR. He's saying that naturally the APC feels disadvantaged, particularly so in the Western area, which is why they may even walk out of Parliament.
If they pushed the amendment.
That particular section, not the other areas, by the way.
And so that is the reason why you cannot stop the president from proceeding with his constitutional mandate. You have given a scenario.
The timing is apt.
Very apt. We elected him to work for us. And if he's not doing it, we are going to pinpoint and say, Mr. President, why are you not doing your work? Why are you not doing A, B, C, and D? Parliament is not ready. There's separation of power. That is their duty. That is their responsibility. Do yours and let's forge ahead. So that is how I see it. That's my position. And these are the things I captured in my position paper.
So Anne, say the president does this, which he has done now, the appointment, then Parliament approves, and we go through with the constitutional review process, the amendment becomes ratified. How do you think all this would play? How would it unfold? We get Edmond Alpha there as the electoral commissioner, and then we amend the constitution now, two different processes. What would become of everything?
Okay, firstly, none of the parties would have breached any provision of the law. The president, consulting with political leaders, appoints, Parliament approves. Parliament, on the other hand, goes through the amendments that is before them, and they think it's okay, they can pass it into law. Also note, the president has the power to either assent the said bill becoming a law or not. If he doesn't, there's a time frame that the said bill can become law, even if he does not assent it. We have not reached to that point yet. These are all provisions in the law, and nobody would have breached any provision. If they passed it into law, it is their function. Those are some of their duties. If he appoints and they approve, it is his function, it is his duty. Nobody has breached any provision of the law. That's my position.
Yeah, while nobody would have breached any provision of the law, wouldn't that be a bit chaotic in the society to deal with? There's already an electoral commissioner who cannot be removed until he ends his term, unless on legal grounds he is found wanting. But he would have to stay in office until he completes his term. Now we would have a whole committee set up that their sole responsibility would be to figure out who should take the position that somebody is already occupying, only waiting to end his term. What would become of that committee? How useful would they be anyway?
For me,
if what they were appointed to do has already been done.
Well, that could not be the only appointment they would make. There is a tenure to the position of a chief electoral commissioner. As per the Constitution, 5 years. These people who may form part of the search committee, they are not going to do a one-off job. It's something they will continue with. It could be for the next electoral commissioner or commissioners that will be appointed. And so there is no chaos in this.
So for the next maybe 3 to 4 years, they would just not have any input to make in,
they would have,
in the electoral commissioner.
Fabian, we do not have any agreements with, firstly, death is inevitable. It can happen at any time. We are human beings. People can do anything within the clause of their functions. There are provisions that says you'll be removed for A, B, C, and D. So anything can happen. We cannot say they will be there for 3-4 years without doing anything. No, I don't agree with that position. There could be anything. Anything can happen. Someone might choose to resign.
Do you think the commissioner can resign?
Sorry?
Do you think the commissioner can resign?
Someone might think, it's conditional. Someone might think to resign and say, you know what?
They might think not to resign.
Yes, of course.
They might also resign.
It's a 50-50.
Yeah. So you see, there's no chaos in it. They have a function. Let's say they passed the bill and President assents it and it becomes law. And there are some issues with respect to the commissioners. Their functions will be triggered and they will begin to I have issues with the composition of the new bill with respect to the search committee.
Okay, what's that problem?
I see some vagueness in those that should be appointed.
Okay.
I was looking at it last night and he said the president shall, for the purposes of nominating chairman of the commission, appoint such a nomination committee comprising 1 person representing interreligious council, 1 legal practitioner qualified to hold office as judge of the High Court. There is an issue with that. 1 person representing civil society, 1 person from the private sector. There is an issue with that. 1 person practicing as a qualified journalist in Sierra Leone. I have an issue with that. There are established.
Why do you have
I'm coming.
Okay.
There are established bodies manning the affairs of these professional heads they made mention of. There's SLAJ, there is the Sierra Leone Bar Association. I guess there is also a body.
And now the Lawyer Society.
No, let's forget about the Lawyer Society.
Okay, go ahead.
Let's forge ahead. Don't give credence to illegalities, please. And so, the vagueness I see in this is this. There are other provisions of laws that says a member of the Sierra Leone Bar Association or member of the Sierra Leone Institute of Chartered Accountants, a member of the engineers, you make it certain. You don't leave it vague. And so if you leave it that way, what you're doing, any member, the president would just choose any person.
The Attorney General was here. Let me just clarify that. His argument was, he told us here on this very program, that the reason why they left it like that, they didn't expressly define all of these clauses, is because they're allowing Parliament to do the job. Okay. Now to define these things and set the bill in the proper way. And so that's what he is saying. Now let me speak to... I argue that there are other places, in fact, other sections that are very vague. No definition. Even with the particular, electoral system that we'll be using, there are no definitions to it. So let me speak to members of Parliament. Types of here even. You see?
Let me speak to members of Parliament. I guess some of them will be listening. I please want you to look at that bill critically. Don't just pass it hastily to say we have added to our tally of the number of laws we have enacted during our tenure. Look at it. We are doing it not for today, we are doing it for posterity. We want to make progressive laws that will not give us headaches. We will not come back and say we want to repeal or amend or bring A, B, C, and D to it. Just do your job. If you do not have the legal expertise to go through those provisions, nothing stops. In other countries, you have members of Parliament that solicit the services of legal practitioners when they have bills. And they sit down and they look at those provisions and they discuss it. They can also go to their constituents. Best practice demands. Go ask the people, what do you want? We have this before us. I am representing you. Is it okay? Is it something we can go by? And for me, like South Africa have the PR system, and you have political parties there that have not won the presidency, but they have been representing their parties in improving, increasing their representation in the House. It's something that they can do. Let's make our democracy very vibrant, our democracy very consultative, our democracy very open.
At the end of the day, Barrister, the question still revolves around waste of resources and time. What if this particular, bill becomes law eventually? Then don't you think this whole thing we're discussing here would have defeated even the spirit and purpose of why they had the Bintumania Agreement, the tripartite report, right onto this stage? Because the reason why they introduced all of those clauses, 50 of them or so in the tripartite report, was for us to revisit or relieve what happened in 2023. All of these disturbances, if you like, these malfeasances, that we are discussing now, should not have even happened in the first place, which is why these people had come together to do this thing. And now they are trying to, if you like, amend sections of the Constitution that deals with elections in this country. And the spirit of it is that, that wrongs are corrected. So the question again, why not wait? Why, allow these people to pour resources, the states, let's say the state, to pour resources in this process? At the end of the day, we don't get to use it. Because if this man is appointed eventually, just wait, if this man is appointed eventually, by Parliament, then of what use will that particular section be to the next election in the first place? That's the question, actually.
I know.
So you see, it would be of no use to the country.
It would be.
They would have already hired the man. And the law says that you cannot just remove the commissioner from office.
Yeah, he has security of tenure. There is not going to be waste of resources.
You feel so?
Yes, because
even the president will not be constituted even. And that's the spirit of the law.
So now you're saying the laws will not be enacted. Is that your position?
No, I'm saying that after enacting this particular bill, it comes to law.
I think I have answered that question earlier.
The president cannot just wake up and even remove this man because he has security of tenure, as you've said.
He cannot.
So you see, meaning that particular section, the search committee and everything therein,
will be redundant. That is what you said. No, I don't agree. Fabian asked a question and I answered.
That particular area will be redundant. Don't you think so?
No, Fabian asked a question and I answered.
Okay.
And I think it is the same question in another way. That search committee is not going to do a one-off job.
Okay.
It's going to be continual. It's going to be part of our laws. There could be vacancies by reason of death, illness, misconduct as provided for in the Act. And when that happens, the search committee's position or duties are triggered. They go into action. So it's not going to be a waste.
But the commissioner could not die.
Well, we pray so. He is human. I am human. I don't even know when I will pass away. Maybe after here. Who knows? God knows.
May God give you long life. But I'm just saying.
Yeah, so that is the position. And for me, I don't see it as a waste. It's something. Let's hope and pray that our members in the House will look at the laws, the bill critically and give us the best. That is all what I want. Give us the best. Something that we can apply with for the longest of time and not have a need to go back to them and begin to review or repeal.
Yes, can I just butt in? I think what Sawane has not directed his mind to in all of these discourses, that the tripartite recommendations are born out of the challenges and issues we had in 2023. And in wanting to prevent recurrence of those challenges, this committee sat and decided on certain things which would help So to say that, oh, we don't have time, or we can just go back to the hold, that's why we stated in a position, in a press statement, that we would be revisit. We think it could give us the reason to revisit what happened in 2023. That is why we're canvassing for this to take effect before 2028. So that, I mean, I said it some time ago that if we adopt all of these recommendations and then a party loses an election and comes out to the public to say, oh no, we were rigged, oh, the elections were stolen from us, we would be the same people to tell that political party, but go sit down, this was transparent. Yes, we the people will tell them, because the recommendations were followed. They have been part of our laws and they were followed to the letter. So that is the background. We're not saying, after 2028, we don't want a recurrence of what happened in 2023. And here we are for 2028. So the only thing that is of good conscience is to expedite the process and adopt these recommendations. So we have a transparent, free and fair election.
But can I draw your attention to a provision in every laws in this country that talks of date of commencement? The 1991 Constitution, the date of commencement was the 1st of October 1991. Members of Parliament can pass this law and they can give date of commencement. They will say this act does not come into function, in fruition or in effect until 2029.
So what will be the purpose of it then?
The purpose
is for 2028 elections. That is why they have, you said cherry-picked.
I'm coming, Bami.
They have actually taken electoral issues.
I'm coming.
Because we know we cannot do the whole constitution now. But since the concerns are on elections, let us identify those electoral issues and get them involved.
His fears with respect to the efforts of the tripartite committee would be handcuffed. I put it in my own words, is that there is always commencement for acts. When those recommendations subsequently find their way into our laws, there are going to be commencement dates. I give you an example, the Criminal Procedure Act was passed.
But this is a different circumstance.
No, I'm coming. Okay. It's an act. Even the Constitution is an act.
I mean, circumstance, because the reason why these things are happening is because
I know there are issues raised with respect to the 2023 general elections. Yes. I know. And the recommendations, there are over 80 recommendations. And honestly, humanly speaking, it is never going to be possible for the implementation of all 80 recommendations before 2028.
Your arguments will explicitly defeat the chief ministers, because he said they have implemented up to 80% of those recommendations.
80% is not 100%. I'm not defeating his argument. I didn't listen to his discourse. But 80% is not 100%. So humanly speaking, it is not realistic that we will have 100% implementation of those recommendations. And it is not even also realistic that those recommendations will all find their way into our laws, because members of Parliament will have to vet those recommendations. Mind you, these were people coming together, 3 sets of people: the ruling government, the SLPP, the APC, and international partners. And members of Parliament are there waiting and say, okay, let's see what these 3 sets of people have put together as recommendation. Do they fit our situation? Do we want them to form part of our laws? So that is what I am saying. It's
Gentlemen, would read out some of the messages that have come on our Facebook page as we try to round off. So Mark 10, New Englandville, says, Mr. Alpha has not been publicly associated with any partisan political ambitions. His career reflects that of a neutral electoral administrator committed to electoral integrity, transparency, democratic credibility, and institutional independence. His role demands non-partisanship under Sierra Leone's electoral laws. No Morel says, the Constitution does not expressly require the President to consult any person or body before appointing an electoral commissioner. Momo Vandi says, these politicians are extremely hypocritical. When EBK appointed the Chief Electoral Commissioner, APC politicians were okay with it. Now that it's BO doing the same, APC politicians and operatives are everywhere crying. No Morals is saying, read the Constitution. Mystic Dwozak says, we need a deep consultation in our political space, especially when it comes to the appointment of individuals who are heads of the electoral sector. The appointment of the new ECSL chief has brought mixed feelings among Sierra Leoneans. No Morel says, go to the Constitution right here, the section where the president should consult APC party before he appoints the ECSL commissioner. Write it here. No Morals again is saying, you're telling us the president should consult. I am saying not even Parliament must be consulted. Only approval is required by the Parliament. This argument always about the president to consult before appointing people is just dishonest and irrelevant. The president is the fountain and honor of the Constitution. Who is supposed to question him on appointments? And another message here from Minister Abdul Denke. It says, it's the executive constitutional prerogative of the president to appoint officials for national service without any consultation. The political truth is, as we go through the constitutional amendment, is our selective concern and ability to subscribe to the supremacy of the law. Are we ready as a nation to comprehensively honor the sacredness of the law, which will serve as a very strong foundation for overall development? Your response, gentlemen?
Yes, I think most of the messages you read, Fabian, are saying that the president cannot consult. I mean, that is absolutely wrong.
Yeah.
Because the Constitution, by Section 32, is unequivocal on consultation.
Yeah.
It says the members of the Electoral Commission, that is Section 32, Section 3
Yeah.
of the Constitution says, the members of the Electoral Commission shall be appointed by the President after consultation. Right? So, I mean, for that text to say the President should not consult, there is nowhere in the Constitution that is wrong. In fact, that is the reason why there is a provision, Section 171.
14.
Yes, subsection 14, which tells us that it is not incumbent on the president after having consulted
Yeah.
to follow the advice of the consultation. So it is not correct to say that the president cannot consult. The Constitution is clear on that, you know. And well, on the issue of non-partisan, right, that is why we're saying the nomination and search committee as it is a bit of a solution to appointments being done on partisan notes, because this search and nomination committee would present to the president those people they think they have searched on, they have researched on, they have identified, present these people. So it's not the task of the president to have looked at anyone to say, oh, I want to appoint you. So to some extent, it would help to reduce or mitigate the partisan loyalty that are seen in some appointees. You know, in fact, in our position paper we submitted to Parliament, we said we will look forward to depoliticizing this process, that the committee members, the nomination and search committee members, are tasked with, are given the right to appoint their own representatives rather than, you know. So we have made note of that, to depoliticize, because we want to save all of these assumptions or all of these insinuations or beliefs that most of these appointees have partisan loyalties.
The only issue, yes, of course, what he said is correct with respect to consultation. The president has to consult. That is a constitutional provision, and he is not bound by the views or opinions of those he consults. He can choose to go on the other hand, whilst they say A. However, the Constitution does not provide the means or the procedure by which the president consults. He could decide today and say, my consultation will be, I call all leaders of political parties and we sit down and we talk. Nothing stops him from doing that. He could ask, like he has asked, that send in your opinions and your views. He could say, I delegate my responsibility to my minister of A, B, and C. Go and talk with political leaders and come with their views for me with respect to appointee by me as the Chief Electoral Commissioner. It is his power, it is his responsibility. So it is not provided for. And let's look at competence again. When it comes to appointment in those positions, you want to look at a texter made mention of the competence of the appointee, integrity of the committee, and you'll also look at the life of that person in that institution. I have had time to interact with the proposed appointee. I have seen the way he has acted. I visited my chiefdom where there was an election. I saw the way he handled it. And the competence, the integrity, the stature of that person in manning or handling the position is very key. Political affiliation or support or partisan consideration, it should be looked into. But how do you prove that? It's by membership. Okay? In America, I know some of the secretaries of elections, they are members of political parties. In our country, we will look at it and frown at it and say, no, you should not be a member of a political party to head any of the institutions that conduct our elections. We should transcend our political loyalties when we are performing functions in public services. We should transcend it. You could have your loyalty. That does not mean you should not perform the functions as elected or appointed for. And so, like he said also, the search committee will go deeper, very deep, to bring out the things that members of the public could not see in reaching a conclusion and say, well, Mr. President, we think A is the person we want you to appoint. Or these are the 3 or 4 names we think you can look and you can appoint. So, by and large, we are still on track. The laws are still intact. The tripartite, the recommendations in the Amendment Act are not just tied down to the tripartite recommendations. They also comprise recommendations from the Kawan constitutional review, and so it has been coming for the longest of time. We've been looking at it, discussing it, whilst we were not even here. Some of us were not even lawyers. People have been talking about the Kawan recommendations, white paper, and this sort of thing. So we will hope and pray and wish and long for to see some of those beautiful recommendations form part of our laws. So for those texters who said there should not be consultation, no, there should be consultation. If the president refuses to consult, he would have breached the provisions of the law, and it would have formed part of their position paper. You heard him, he said here, no, we are not saying the president breached any provision of the law. We are only looking at time and good conscience.
Barrister Sawane, I mean, earlier you picked out some lacunas in this particular tabled bill in Parliament. I mean, in good conscience, would you mind perhaps to, if you like, expand on it a little so that, I mean, the public gets to understand? Because a lot of people have been having bites on this particular bill. You know, its essence and the crucialness of it, you know, to our next election. You wouldn't be the only one, by the way. A lot of people have actually expressed concerns about the clauses therein. Yeah.
I looked at the provision that has to do with the search committee for the electoral commissioner, because the discourse had to center around it. I'll be coming out with another position paper with respect to the entire bill, picking out issues that I think members of parliament would have to look at critically before passing it into law. But my concern has to do with the uncertainty as to representatives on the search committee. I made mention of professional bodies that provide representatives. I give an example of the Political Party Regulation Commission. The members, the Institute of Chartered Accountants have a representative on that commission. Bar Association also has a representative on that commission. If you give a law and says we want representatives to come from those professional bodies, it's certain, it's fixed. It is something that you cannot be using arbitrarily. Those who appoint, if there is no certainty as to who appoint these people to those committees, they can wake up one morning and form a civil society body and appoint one person from there and say, this is the person I want to be represented in that such committee. And it will also defeat the spirit of the amendment. We are talking about that members who go to these independent institutions should be apolitical. But if you do not narrow it down and you just leave it open like that, you say members of the private sector. I have a company, I have a cleaning company. I'm a member of a political party. If we pass this into law, nothing stops the president from appointing Sawane as a person in the private sector.
So the vagueness.
It is vague.
Concern.
So that was why when you said the Attorney General said we leave it open. Well, let them look at it again. Let us narrow it down to those professional bodies recognized by our laws and let them have representatives from these places. And when you do that, you save those who appoint. You also save the spirit. You also bring the spirit of the said act into play.
Okay, Claude? You'd like to have a bite on this? I mean,
Oh, yes.
Your views around generally this bill?
Yes.
Not essentially that particular clause, but the entirety.
Generally. Okay, even on the clause, I'll start with it.
Okay.
On the search and nomination, the functions of the search and nomination committee are unclear. So we need clarity on that. And then we also, there is a gap on whether the recommendations by the search and nomination committee are binding on the president. The amendment bill does not state that. Whether if the president, when the search and nomination committee would have recommended to the president and the president does not comply with the recommendations, what happens, right? Is it an issue that should be taken on, that the president has not complied with the recommendations of the nomination and the search and nomination committee? These are gaps. We also have this issue of the 20 and 25%. Remember, they're saying the 55% threshold is now being reduced to 50% plus 1, and then that you should have 25% in
Popular
two-thirds
votes
of the districts out of the 14 districts. So we're saying what is contained in they are now, okay, the bill is saying 20%. So we're asking, where is that coming from? Because the tripartite is saying 25, but what is seen in the bill is 20. So we're of the opinion that does not carry the mandate of the people, because what the people, as per the tripartite recommended is 25%. Why reduce to 20? All of that, because if it's the will of the people, then you reflect what's in the will of the people. What was said by the people. So there are these issues. We also mentioned on this PR system.
Okay.
We're looking at the PR system in tandem with the Gateway Act. Okay? It says 30% of female representation in governance. Now, with the PR system, which is being recommended into the amendment bill as a way to go, it stifles the chances of women. Because don't forget, the PR system, as you mentioned, lists the preferred candidate as per preference, order of priority. So if a political party has all the female candidates at the bottom, they have lesser chances to be elected. So these are the things, these are the considerations that we have put in. The independent candidates. Now we're seeing financial capability instead of service. Democracy is not money. right? They're saying, oh, if you want to become, a presidential candidate, there has to be the satisfaction of sufficient financial. Who determines what is sufficient financial capability? It's nowhere. The eligibility for presidency is clear in our constitution. You must have attained the age of 40, eligible to be voted in parliament, blah, blah, blah. Able, you can read and write, all of that. But now to come in with financial, we think, oh, you're putting money into democracy. There could be a very good individual who can deliver this nation, but maybe he hasn't. And that is why you have political parties. Okay, if you have an independent candidate, he might have support. He might not own the money, but he might be having support to fund his campaigns. So you don't have to say sufficient, and that is subjective. What you might determine as sufficient might not be determined by some other person as sufficient.
The former Attorney General Fitzgerald Kamara had described that as the Jagaban clause.
Oh yeah.
When he was on our program a few weeks ago.
Oh well, yes, because maybe they see Jagaban as
but something of crucial importance is this. I would like both of you, your bite on this. We're discussing currently, no doubt that they've chosen PR, right? It's in the bill already. Now, what we should be discussing, as Phoebe was here the other day, we asked Dr. Honorable Bernard Lahai. She said the threshold should be left at 7%, for example, so that all other smaller parties could be voted in, right, to represent their people in Parliament. Dr. Alpha Khan, who is the presidential spokesman, has said that, well, 5% is his preference, so that all other parties will be included in this. Because what we're now seeing is a one-sided parliament. Only the two oldest political parties are there. What are your views? What percentage would you, I wouldn't say prefer, would you suggest to parliament if you were asked?
Well, the dangers with reducing the percentage would be how many seats would the
parliament accommodate?
Yeah. Because
and that was the Deputy Speaker's argument
exactly.
Yesterday. Yes.
Because if you reduce it to 5 or 7%, and then you might have all of those parties
having seats.
Yes, nominated or being voted into parliament. And so how many seats can we accommodate?
He said it's possible. There's an ongoing policy, calls it the reconfiguration of the well. They would have to do it at the close of this particular parliament so that they get more seats added, about 80 or so, he said yesterday.
Well, if structurally the parliament can be otherwise, conditioned to accommodate members of the parliament, well, yes, but given the space that we see, maybe that's the consideration why we have this higher threshold. I am not in for just APC and SLPP. Okay. Just so I am on record, just APC. It's not all inclusive. Okay. Yes, we will need more, but to reduce the threshold to 5 or 7% would be dangerous.
Okay.
It would be better for them to do the reconfiguration or what have you of the House before they decide on the threshold. Mind you, we were not having 132 members. Yeah. It was before the 2018 general elections. We used to have 120 or so, and they reconfigured it to 132. So whatever they may want to have as their threshold, let them look at what we may need at the very House of Parliament. Like Bami said, it will be difficult to have. We're a very small country. You want to have 160 or 260 elected members of parliament. Yeah. Are you thinking of having 2 houses, lower and upper houses? Do we actually need that for a population that is swinging between 7 and 8 million? Yeah. I don't think so. So let them look at it. So I may not give any figure here. He maybe made mention of female representation, that PR would affect that because based on the list that will be provided. In the bill, there's a provision, section 4. It calls for the 30% representation from women nomination on political parties representation. It's there. Section 4(9). It says at least 30% of the parties' nominations for national and local government elections shall be women. And so it is provided for in the Act. So I remember before 2023,
the placement of it.
The placement
on the ballot.
30% is not a question. So how do we achieve that?
And so it boils down to what the ECSL before the 2023 elections. Yeah. I said here that I am a politician. I was involved. And I saw the lists of how women were captured. I will tell you all those lists that did not have 30% representation of women were refused.
Okay.
They did capture all those representation, and we have women, and if they had not included them in their list, there was never going to be a way ECSL was going to accept it. So now that it is being legislated, it's not yet, I bet you they will preference the lists to capture the 30%, because if they do not do it, there are provisions in the law that it will not be accepted. And the one that has to do with 50% plus 1, it is not coming from the tripartite. It comes from the Kawan constitutional review recommendation. So it has been there. It's something that we have been pushing for again and again. And there are countries that have been practicing PR system, and they've been thriving. We admire the parliamentary system in South Africa. That is a place where you see the opposition going toe to toe, neck to neck with the ruling government. And you see, is it EFF? Julius, he is slightly above 10 years now, and he has been increasing his number. Who knows, maybe in the next 5-10 years, he'll be forming the government of South Africa. I don't know if any other party would defeat ANC, but it's a possibility. So let them put the fine things together. Let them put those things that are not okay for the bill, and see how we can get a better law, progressive law.
Okay. Barristers, we're closing off. What's the take home? I'll start with you, Claude.
The Lawyer Society have heard many times when people are commending His Excellency the President and the government of Sierra Leone to be a listening president and a listening government. So we're on the back of that. We're hoping that His Excellency the President will reconsider this appointment and exercise restraint, so that we'll conclude with the Search and Nomination Committee and have the will of the people as is documented in the tripartite and CRC reports to be reflected. Right. That is our take, and we're waiting to see how far our president can listen to us.
Thanks, Barrister.
Thank you. Consultation is not consensus. And consultation does not mean the person consulted, his views should be accepted hook, line, and sinker. The president is not bound or tied to appointing Edmond Alpha. But in his wisdom, after consultation, if he thinks Edmond is the best person for the time being, so be it. The search committee has not been set up to appoint Edmond Alpha. It's been set up to appoint the Chief Electoral Commissioner. It could be anyone. It could be Bami seated here. It could be Sawane. It could be any other person. And so let's look at the law. Let's follow the law. Let's do the things that we know are provided for in the law. We made mention of the spirit of the law and the letter of the law. Let's follow both. Let's serve the people, taking our consciences and the law into play. Let us not separate them. Bami said the president is a listening person, and I know he listens. If it is not good for us, he would not follow it. If it is good for us, I am sure he would follow it. Right. And let the separation between the arms of government continue. Like I said in my piece, there are layers. Presidential consultation, appointments, and approval. Let us not skip any of these stages. Let us follow them to the letter, and let's get the best. If Edmond is not the best, Parliament, please, 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 do not approve him. If he is the best, please give him to us, and let's see what he can do for us for the next 5 years.
All right.
Thank you very much, gentlemen, for being a part of the program this morning. And thanks to you, our lovely audience, for tuning into the program.